to the Science Talk. Today we have with us Renate Weisse, who is a patent attorney. Hi Renate, wonderful to have you on the Science Talk. How are you doing?
Hi Pranoti. Yes, I'm very well and it's a pleasure to be here with you. Thank you.
Let's start with the introduction. Could you please introduce yourself?
Well, there's a lot of things to be said about me because I have a profession which is very rare. The one thing is that I'm a patent attorney and a European patent attorney, and we are only like 400 to 500 women in Germany, and it's overall only 3,500 patent attorneys in Germany, so hardly anybody knows that patent attorneys are not lawyers, but scientists or engineers or something like this. So what I did is I studied physics and I studied a little bit of chemistry, and only then you start with your legal education, 3 years in the patent attorney office. In my case, that was my father. So I have, the important thing is we patent attorneys, and I in particular, I'm one of you. I'm a scientist. I have done atomic absorption spectroscopy, and I know a lot about optics and all kinds of things, and I have done programming. So I'm a very knowledgeable in science and in engineering nowadays. I do a lot of engineering as well, and only then I started with my education and my training as a patent attorney. So I have no idea about family law, traffic law, or something like this. It's all technical patents, and trademarks, and this kind of thing. And what do I do also? I'm a little bit of an activist. I try to change things a little bit. We are only 6% inventors, female inventors in Germany. And I have 3 children, so that keeps me busy all day.
So you're one of us, you're a scientist, and you're not a lawyer, but you're more of like a bridge between the lawyers and the scientists. So you're more like somewhere in between. You're a patent attorney who understands scientists, who has been a scientist herself.
Yeah, not only that, it's very important. Like we're the interface to the lawyers in patent infringement proceedings. The court is constituted of lawyers, so we have to explain to the lawyers what the scientists have invented. And sometimes inventions are really complicated. You know, when you have something complicated, optics or that kind of thing, that's really important that you understand the invention. And with the lawyers, you never know. You know? so we are the interface.
Okay, super. So could you explain, when does it smell, like, to quote you, when does it smell like an invention? How do I know if I have invented something, or when does it smell like an invention, basically?
Yes, well, you see, inventions are always glorified. People think, ooh, this is an inventor, but I never be an inventor. You know, they think they're inventions, oh my God. And but it's not like that. The technological progress goes in only very small steps. It's very important to understand that. And so we have 70,000 new patent applications every year in Germany. So you will appreciate, well, you don't have always groundbreaking, disruptive technologies, but you have those small steps and small inventions. And once you appreciate that not every invention is those big things, you will tend to be more alert. Oh, look, this is something small, but if we have an advantage, then this might be an invention. I'll give you examples. If you have something and you have a known measure, and you apply this known measure without any surprising effect to a known device, you put rolls underneath a table and then it's rolling. Well, this is no invention. Sorry about this. That is too trivial. Even if that table had never rolled under his on his legs, you know. So that is new, but it's not an invention. But if you have something and you have a further effect, if you have surprises are very good. Surprises is always inventive. if something is unexpected, then it's invention. But sometimes you have these little advantages. You make a slightly different design and suddenly everything is cheaper. Or you combine something and then it's easier to adjust. Or you make an amendment and then you need less material. Something that makes things faster, better quality, less expensive, less manpower requirements, easier to adjust. All those, and sometimes it's only a very little thing that you need to do. Those things are inventive, generally, unless somebody has done the same thing before. That's always, it must be new and it must not be obvious. That's what the law says. So this is inventions. It must be technical. Technical is a big thing. Even clothes can comprise inventions. I had a designer who had a new dress. He could wear it inside down and upside down and I don't know what. And that was inventive as well. The patent has been granted. So it's not only if it's grease on your fingers. Inventions can be in any kind of technological field. But what's not patentable is mere software in the internet, business methods. That's not patentable. But all the other things, yes, you can get patents for such small inventions. What is important is not up to you to decide. I think we come a little bit to the inventorship law, but once you think, oh yes, that is something, there's some advantage and I don't want the competitor to use this, or there's an advantage at all and you don't even have a competitor if you're a scientist. You have competing scientists, but you don't have a competitor in the production or for a product. But if there's an advantage, if something goes faster or better, think about, could this be an invention?
Okay, all right. So that's on how to smell an invention a little bit to make it not obvious, no one has done it before, make sure that it is actually improving the efficiency of an existing process to improve it, something along those lines. So, well, as a scientist, let's go with as a scientist. So, if I'm like, I think that I'm an inventor, but I'm not entirely sure yet. So when do I come to you for advice?
Well, it's not up to you to decide. Basically, when you're employed, it's very important. You're legally obliged to inform your employer about your invention. So that is a very important point. And because of this legal obligation, you can tell them about everything that you do, what is new and what you consider as not absolutely trivial. You just inform them, and then they decide, is this an invention or do they call a patent attorney? If you're a free inventor, well then you only call me if you can make money with it. You don't get things patented if you don't make any money with it. There's no point in it. But when you're employed, then obviously you're not paying for the patents, and then you don't have to decide whether it's an invention or not. Let the patent office and your employer and the patent attorneys and all those people decide. Your only obligation is inform them, because they have no second sights. They cannot know that you've done something that could be patentable. And if it's not, well, there's nothing to be ashamed of. Well, then you've made an Erfindungsmeldung, and you've informed your employer, and they say no, we don't want it, or it's not patentable or something. And fine, And if you only have 1 out of 5, it's fine. You don't have to be ashamed. Just dish them out.
Right. Yeah, that makes sense. So it's inform the employer. Always the first thing to do is inform the employer, and then come to you for advice. Unless you're self-employed or you have a startup, then I hope they can approach you.
Yeah, you need to have a business case behind it. Your employer knows whether they have a business case or whether they want to have a patent or whatever. If you're a scientist, sometimes things are patented and then there's no business case. You will notice that only when you don't find somebody to license the patent or the invention. And but that again, this is not your task. Your task as a scientist is to make inventions and to find new things and to investigate things and all this, and to design new instruments for furthering the science. And your task is not to make the money. That's other people's task. And let them decide.
Mm-hmm. Okay, super. So let's say I've made an invention, I've informed my employer, and now we are trying to file a patent application. So at this point, who pays for it?
Everything is out of your hands. So that's very convenient. If you're employed, it's a very convenient position. The employer has to pay for everything. Now, there are a lot of rumors in the internet that patent attorneys are so expensive, which is true actually, depending. But think about it. If you have made an invention which earns, say, millions of euros, and would you be too stingy to pay a couple of €1,000 to protect your invention, or would you rather have the competitor use it? So there's no question of whether it's well invested money. So basically, to just let you know order of magnitude of how much it costs, when you apply for a patent and you secure your priority date, the initial investment you have to have is about 4,000 to 6,000 euros. In the scientific area, it may sometimes be a little bit more, but it's rarely less than 4,000 and is rarely more than 6,000. So that's just the order. The problem is this is not all, and that makes our bad reputation. A patent is only granted after examination, so you file a patent application and you try to get a big scope. You want to protect all varieties so that nobody can circumvent the patent so easily. And then when you have such claims, the examiner will start examining, is this known in the art? And they will always find some old prior art document from 1896 and say, hey, look, here's something that falls in the scope of your invention. And when he says that, and then he says, your invention is not patentable. And all those inventors that I know who do this the first time, they start crying. They say, oh, Frau Weisse, you said it's patentable, and now the examiner says it's not patentable. And what you have to understand, and this is very, very important, what you have to understand is that this is not a refusal. This is a mere office action, and an office action is an invitation to reply. So I read the prior art, I read the examiner's notes, and then I reply, and sometimes I amend the claims, narrow the scope, clarify something. Sometimes I don't amend them at all, and I tell the examiner, hey, listen, there's a word that you have ignored, and it's not outside, it's inside, and outside is all well known in the art, we know that, but our invention is inside whatever device, and this is so completely different, and before nobody could do this, and this is all new and non-obvious. And in most cases, the patents are granted. And the reason for that is that my inventors, they know what they're doing. They know the prior art, usually. Sometimes we have, I had cases where none of us, there was some prior art that we didn't know, and it's 50 years old and nobody could know. Well, then, I'm sorry, then the initial investment is gone. but yeah, this is a very sad thing, but it happens very rarely, because usually the inventors know what they're doing, they know the art, and obviously it's sort of a negotiation about the scope of the patent, not about whether it's patentable in principle. I very rarely have problems there. And even if I have, sometimes you get examiners that you don't like and they don't want to grant the patent, and there's always very difficult proceedings. Very rarely. Usually they're nice. And then he refuses, Sometimes I get impatient and say, well, then issue a decision and then we'll appeal. And then we go and appeal the case, and then we get the patent, and simple as that. So that's how it goes in. And those proceedings, we were talking about the costs. Obviously, depending on how the proceedings go, sometimes I get the patent granted after one office actions, and then it's a further maybe 1,000 or 2,000 euros, and then we have the patent. So the overall investment is maybe 6, 7, 8,000 euros, and sometimes it's very complicated, and we end up with a overall bill until it's granted of 15,000. It's possible as well. And I cannot say where between the 7 and 15,000 euros it'll be, but that's about it. And we're talking about 2 to 3 years. You don't have to pay all this money initially. The initial investment is only for the application. And then over the years you have to pay a little bit of patent annuities, and you only proceed with the patent when you expect money to earn money which justifies such costs. You will not maintain a patent purely because you're so proud of having made an invention. You know, I wish you all the best having made an invention, but if you want a certificate, go and do something else, get certificates for high jumping or something, but don't have patents, because the patents will become increasingly more expensive. So, and within 1 year you have to decide, do you want foreign filings? Do I need patent protection only in Germany? Then a German patent will suffice. But sometimes you have competitors sitting in the US and in Japan, and then you will have to have maybe a European patent, a US patent, and a Japanese patent. You don't have to file them immediately, but within 1 year you have to decide. And if you file an international application, you have to make this decision within 30 months. But at some stage you will have to decide, which patents do I need? And as I said, when you have a competitor in the US, it's no question that you will have to make a US patent. And I'm admitted before the German Patent Office, and I'm admitted before the European Patent Office, but not before the US Patent Office. So I will call my colleague, or I will write them a letter and say, look here, dear Robert is his name, and can you please represent my German client before the US Patent Office? And he will say, yes, thank you for your order, I will do so, and here's my bill. So he will obviously charge as well, so you have always 2 patent attorneys involved, and that costs money. And the Japanese, he will say yes, and we will provide. We will need a Japanese translation because the examiner is Japanese, and this translation is very expensive. And the European Patent Office, where I represent, they will say, yeah, well, you get patent protection in 30 countries, so we would want high official fees. So from this, you can appreciate. International applications are very expensive, so you have to calculate with 10,000 euros per country at least for the filing, and then for the consecutive examination. So that's all very complicated. It's just as well when you do that with professional support. So this is what it's about with the money. But the initial money is relatively little, if you call 4,000 to 6,000 euros little, but it's sort of affordable. Yeah. Say that. So that's
absolutely. And as a scientist who is employed either by a university or a company, the company or your employer is taking care of all of this. As an inventor, it's not, you don't have to pay for any of this. It's your company and employer who is their headache. Your job, as you said, is to invent and inform your employer, and then the employer then makes sure of all the whatever happens after that. All right, yeah, that does make sense, and it does seem like a very the patent application filing process does seem a little bit like submitting a scientific article, where the reviewer is coming back to you with their comments, and so it's more of a conversation starter and not a refusal of the manuscript. So when you're writing a patent, or when you're thinking of inventing or writing in the inventor, do I have to write the name of my boss as an inventor like I do with the scientific papers, or how does that work?
No, with scientific papers there are a lot of people who contribute to a certain scientific progress, and those who do the constructions and the drawings and who organize the finances, they are named on scientific papers. It's different with patents. In the US, a patent is not valid if not the right inventors are named. So it's very important that the boss may appear on a patent as an inventor if, for example, he or she sets a certain task, because the object of the invention may also be, it is part of the invention. Sometimes it's trivial. If the task is please make something less expensive, well, that's pretty trivial, and the solution is the invention. But sometimes the task is such that it sort of involves a little bit of the solution already, and the task is unusual. And then this may cause a contribution to the invention, and the one who sets the task, that's usually the higher ranking, the big boss. If she has set a good task and an inventive task, well, then she will be named on the patent as well. Who should not be named is people who did not contribute, but who we are grateful to. Those people who organize things, who do the drawings, who check the translations or whatever. We are all very grateful for their contribution, and they shall be named in the scientific paper, but not on the patent, because they have not actually contributed. I always get very suspicious if there's more than 4 inventors on the patent. Then it's usually there's something wrong with it. I mean, I won't rule out that there are several inventors contributed, especially if you do some brainstorming. Then there's several people, and somebody comes up with a solution, and the next one sees a problem in this solution, but picks up and says, well, why don't we solve this in such a way? And then in the end, it's a sort of a common effort. And this is the case where you name several inventors. If you have the wrong people on the patent, and the patent is infringed in the US, and we have the rare case of a patent infringement proceedings in the US, a real court case, the infringer, the first thing their lawyers do is the cross-examination. They call the inventors as witnesses into the witness stand, and there's a lot of blood and sweat shed when they start crying, because it's difficult to be a witness anyway. Even if you're used to it, it's very difficult. Even if you have nothing to hide and you know exactly what you're talking about, being a witness is very difficult. But if you have not invented, they will find out, you can be sure. So I always warn all people either to name people who have not invented on the patent, or to omit somebody on the declaration of inventorship. Those little students who have invented, but who they don't want to have on the patent because they are not employed with employer or somebody. So those people, they are very they should be omitted. Nobody should be omitted, and nobody should be named who's too much. Yeah.
All right, so it's very important to name the people who are actually inventors, and not just for the sake of it, not just for the hell of it, who actually contributed actively. Only those people should be named as inventors on the patents, because it's very important. It's very watertight otherwise.
Yes. And it's fair, isn't it? I mean, you're named as an inventor. And I think it's only fair that only those who really contributed will be named. And sometimes you have those co-inventors who would like to be a co-inventor, but who have not actually contributed. And if they find out you have made an Erfindungsmeldung, you have informed your employer, then they will claim, hey, you have to name me as well. And the answer to this is a sort of a tip from the practice. You say, well, if you have invented something, why don't you make your own inventorship declaration? Why don't you inform our employer on your own, if you have invented something? I have invented something, I have informed my employer, you have the right to do so no problem. And that will mostly put them off if they haven't invented anything. And sometimes that happened to me what you need to know also is you don't need permission to invent. You don't need permission to file your description and your Erfindungsmeldung with the employer. You don't let anybody put you off. And if you don't like your boss, if you think there's some sort of if you have a bad feeling to inform your boss, you can inform the employer. I sometimes advise them to just say company XYZ in such and such street, such and such, and don't put anybody on it. And then they will decide to put it into the legal department, and your boss will hear about it when the patent attorney appears or when the patent application is filed. So that's to circumvent sometimes problems. And nobody can say that you've done wrong, because you only fulfill your legal obligation. And if somebody asks you, you say, yeah, this is what I was told by Renate. This is that you're told by me. And you can always refer to me.
Right. Because you did what you were supposed to do legally. You informed your employer. So yeah, you followed the procedure. So yeah, that makes sense. That's a very good tip. I think this is really, really good. Thank you. Thank you for sharing that. So it does seem like a fair system, a very honest and fair in principle. Of course, I'm sure people find loopholes around it with most of the systems around the world. But the patent application filing and the granting, the whole process does seem very fair and honest and authentic and trustworthy, I must say.
Yeah, we are Organ der Rechtspflege, so we lose our entitlement to represent clients when we our admission when we do something wrong, you know. So I may not advise to do anything beyond legality. So this is very, very important for us, and apart from all those fairness aspects of it, I stick to the law very much.
It does make scientists comfortable to approach you with their ideas, either themselves, through their startups, or through their employers as well. And I hope this encourages more and more scientists to invent and smell the inventions around them as well. How do if I want to get inspired as a scientist and I have no idea what kind of patents can be filed, to get an idea of what, let's say, my employer has done, how many patents does my university have, for example, or my company have? Is there a way to look for it? How to go about it?
Yes, this is a very good idea, to look what other people have invented and patented, because that gives you an idea of what could be patentable in your own field. And how do you go about it? Well, you do an internet search, a patent search in the internet, and it's all free, and it doesn't cost anything. You don't have to register. It's very easy. And the German Patent Office, or the US Patent Office, or the European Patent Office, they all have free databases with all the patents. It's not only that the German has the German patents and the European has the European patents, but let's say the German Patent Office has all patents: Japanese patents, Chinese patents, US patents, from almost all countries. And there's a very simple search. You go on the official website of the German Patent Office. It's called DPMA, and the website is called www.dpma.de. And there you go to Depatisnet. It's right on the front page. It says Depatisnet. You click on there, and in Depatisnet you can do an expert search or a beginner search. And it's in English. It's available in English as well. So if you need to do the search in Finnish, then it's not about looking for Finnish patents, but only sort of the search terms and all this. Then you can go to the European Patent Office. They have it in all languages: Greek, Finnish, whatever you name it. And in the German Patent Office, they have a German and an English search facilities. So you can do the beginner search, and then you put in your own institute or your own company. And if you want to, you can put in some keywords, or if you want to have your competitors' patents, you put in the competitor, and then you get a hit list, and then you can look what's relevant in your field. And if you say search for Honeywell or for Siemens or for Bosch, they have huge amounts of patents, or IBM, they have, I don't know, 2.5 million patents or something. Then without keywords you won't get very far, you know. If the hit list is longer than 100 hits, you need to limit it, because it takes a lot of time to read all those patents. And what you do is you maybe combine keywords or and the applicant, or you limit your search to only German patents. If you know it's a German company, they will usually do first filings in Germany, that kind of thing. And you can limit your, and so that you get a nice comfortable hit list, and you scan through the titles and check, is this something that is relevant for me or not? And when you know, let's say you are in a laboratory and you know your professor has done a lot of inventions, especially when you have a new job. It's a good thing to look what's going on here. Do they do any inventions? And then you put in your professor's name and or your whatever co-worker's name or something, and then you can check what kind of patents do they have, and you read them. And let's say you're like, I would put in something like a shell spectrometer, or I would put in atomic absorption spectroscopy with continuum sources, or I would put in Stefan Florek, who is the main guy inventing shell spectrometers. So that, and then with a combination or even alone, you will get all those inventions, and you will see how much is necessary to get a patent, and what do patents in my own field look like? Because if you don't have any idea about shell spectrometers, you will not appreciate what's good and what's not good and what's patentable. But if you do it in your own field, I think, Pranoti, you are working with carbon something. So you put in your carbon thingies that I don't have a clue about, and then you will see, oh yeah, look, this is patentable, or such and such is patentable. And then you will get a better grasp of inventions, of the concept of inventions, and what belongs into a patent application and what not. Like with a patent application, for example, we only have a few sentences for the prior art, whereas in scientific papers you have pages and pages, who did what and what's all known and all this. No, we don't do that in patents. We have only a very small, brief description of what's there, and sometimes only the patent number, and the examiner can read himself, you know. So, but we go on about all the varieties of our invention. We could use selenium or arsenic or tungsten or whatever, you know, that kind of thing.
Super. So there are websites. I'll put the links also in the description of this this video, so that people can play around and get an idea and get inspired by the variety of patents in their fields, and to know what can be patented, how to smell the invention to complete the circle here, like how to smell an invention and how to be an inventor, if you wish to be an inventor. This has been wonderful, Renate. I learned a lot myself. This is rather a complete new world. It seems like a parallel universe almost that I wasn't aware of so far. The patent attorneys' world, so to say, together with the scientists and the lawyers and everything. So thank you very much for informing me about how to be an inventor if one wishes to be an inventor, and what is the process and what to expect if you are an inventor or wish to be an inventor. So thank you very much. This has been lovely. Thank you.
I have to say thank you to go public with my ideas, and whoever sees this video, please do not be shy to call me if you have something. Even if you are employed and your employer has his own patent attorney, if you want to have me as a patent attorney, tell your employer. You don't have to do with any old white man or whatever, you know, you can choose, and most employers will hear you, you know, and it's don't be shy and be alert. That's what I would like you to be. Be alert, look at your own, have the self-confidence to make inventions, and I'm looking forward to all your inventions. Thank you, Pranoti, for letting me do this.